Hi, I'm attorney Bill Brownchick, and in this video I'd like to explore with you 7 landlord liability issues, things that might come and get you if you're a landlord. You should be aware of these things, so let's go through them. The first thing is the obvious one that everyone's afraid of, and that is personal injury to a tenant or someone who is a guest of a tenant. Now, the best way to deal with this obviously is going to be insurance. Having adequate insurance on your property. Most people have standard insurance on their property, which liability-wise covers $200,000 to $300,000. Way too little. You should have at least $500,000, if not $1 million in liability coverage. If your insurer doesn't sell that much on a single-family residence or condo, then consider an umbrella policy on top of that, which will cover $1, $2, $3 million, so you have adequate coverage. I think $2 million is probably adequate depending on the type of tenant that you're dealing with, and obviously somebody who is a physician has a higher earning capacity if they die, and then thus a bigger jury verdict. But $1 to $2 million should be adequate coverage. $200,000 to $300,000 is woefully inadequate. And since most cases are settled out of court, and most cases are usually nonsense or frivolous, that they cover the lawyer fees to defend you, and that's what insurance is very good for. So make sure you have adequate insurance. The second thing you have to deal with would be liability under the fair housing codes of the federal government or the state. So these are discrimination claims. Someone said that you discriminated against them in renting or renewing or in the application process and choosing them because of the fact that they were a certain race, background, religion, sex. You should be aware of the federal regulations. You can go look them up on the internet, as well as your state regulations, because your state may have additional categories or classes of what we call protected people or protected classes of people. And if they're in a protected class, they get special benefits in terms of prevention from discrimination based on that protected class. In addition, there are local ones, sometimes in a city or a municipality. A very odd one was when I used to live in New York. Attorneys were often discriminated against, so the attorneys got together and petitioned the city of New York to pass a law that says you can't discriminate against someone just because they're an attorney. Good reason not to rent to attorneys, but anyway, that's an odd one, but you should be aware of what those things are. Now, most people are not dumb enough to discriminate against someone because of their race or because of their nationality or their religion or their sex, but there's often subtle things. So, for example, one of the protected classes is familial status. That is, whether or not you have kids and how many kids and the age of the kids. So discriminating, saying you have too many kids and you can't rent this apartment. Or a situation where you're collecting applications from various people who are looking at the unit, and married people, you're getting 1 application, and 2 unmarried people, you're getting 2 applications. That's discriminatory. You're discriminating based upon their marital status. And if they have kids, and they're adult children versus small children and so forth. So you got to be careful of the subtle things. Just make sure you go to a class and read some books on fair housing and the subtle discrimination that goes on that you might get yourself into trouble for. A prime example was a landlord in California had an apartment building with multiple floors, and a small child fell off of a terrace. It was terrible. So the landlord said, well, new policy, people with small children, we're going to rent the lower units to, and people with no children or older children, we can rent the upper units too. Well, someone sued and said that was discriminatory because they wanted the view. And, I don't know whether or not they would have won a trial. They did settle it, but, very subtle things. It's not the obvious ones that people get tripped up on fair housing. So be aware of what the protected classes are in your state and your locality. Be aware of the federal ones. Be aware of the subtle things that come about and the subtle ways in which you advertise, take applications, and screen people. Make sure that you have a good system for screening people and choosing people. So if you just say, well, I'm going to take this person because I like this person better than that person, they were more qualified, you may get into trouble if that other person that you didn't take is a member of a protected class, because they're going to claim that's the reason you didn't take them. So have some sort of scoring system in your file for each tenant X number of points for credit, X number of points for income, X number of points for references, how they filled out the application completely or not, how was their demeanor generally, were they truthful in your opinion, because those are the things that you can score in a subjective way against someone that you think just might be trouble, even though they may be a member of a protected class, and that's not the reason why you're not picking them, but you want to have something to fall back on, some sort of argument in your file that you score everyone the same for that particular property in that particular time when you were taking multiple people in applications for the same property. Okay. Number 3, guest liability and trespasser liability. What? I'm liable if someone trespasses on a property? In some cases, yes, you are. Now, if you're renting to a tenant, let's say a house, apartments are different because you have common areas you have to take care of, but generally, under a lease, a tenant's responsible for maintaining the safety of the property as long as they know about the different parameters, especially if they've been living there for a while and they know what things are safe and not safe. They're under a duty to their guests. But you got to make sure that they know about certain things. For example, I had a rental property where it had a spiral staircase that went up to an apartment above the garage, separate apartment from the house. And in the summertime when I rented it, it wasn't obvious that in the wintertime it gets icy and you can slip on it. So I made them acknowledge in writing that that is a risk. Now they know about it, and now they have a duty to warn their guests. But if I didn't say anything and they got injured or a guest got injured, guess what? I could be liable as the landlord. I'm not automatically liable as a landlord. Just because I own the property doesn't mean I'm liable. Someone who gets injured has to prove that I was negligent, that I had a duty to do something or refrain from doing something, and that I didn't act reasonably with regard to that duty. Okay? So if the tenant is in possession and the tenant caused a condition that either you didn't know about, had no reason to know about, weren't aware that they were doing it, and that caused injury to a guest, you probably wouldn't be liable for that. But let's talk about trespassers. There's something in the law known as an attractive nuisance. Attractive nuisance is something that attracts children, and that tends to be a dangerous condition. Swimming pool is the obvious one. So that's why you have to have a fence. Now, I wouldn't have a swimming pool at all. In some parts of the country they're very common, but I wouldn't have one because I think it's a liability. I'd rather just fill it in. But if the tenant, for example, wanted to have an above-ground pool and there was no fence, even if the regulations locally didn't require it, that's an attractive nuisance, and someone could break in, to the house or over the fence, or if there is no fence, drown in that pool, and you could be held liable because you allowed it. So trampolines is another example, play sets. Just be careful what you allow your tenant to have, because those attractive nuisances could come back to bite you. And speaking of coming back to bite you, what about things like animals, dogs? Well, generally, you have what's called the one-bite rule. That is, unless a dog is prohibited by law, like a pit bull that's illegal in that city, the general rule is you're not liable because your tenant's dog bites someone, but once they do bite someone, you're on notice of that dog's propensity to be aggressive or violent towards other people, and you have a duty to make sure that that dog is somehow chained up, locked up, or gotten rid of. And if you don't, then you could be held liable to a guest of that person, or possibly even a trespasser. If the attractive nuisance didn't cause the problem, but the dog bit the person, that could be something that could come back to bite you, pun intended. Okay? So let's talk about number 4, which are disclosures. There are various disclosures, lead, that's the federal one, and then a lot of states and localities have things for mold, radon, in some jurisdictions, ghosts, people who died in the property, but in other jurisdictions you don't have to do that. So you should do a little Googling and figure out what is the required disclosures by law. Now, even if it's not required by law, you have a duty to disclose all latent defects. Those things are not obvious. So, for example, in the situation where I had the tenant with the property that had the spiral staircase, that was a latent defect in the summertime because it was not obvious that it was slippery because it wasn't snowing at the time. So that was something I should have disclosed. Okay? And I did disclose, and I got it in writing of the acknowledgement of it. But anything that you've done that isn't obvious, that is not an obvious issue of danger, should be disclosed to your tenant so they can disclose it to potentially other people, okay? And just got to know what the required disclosures are, and when in doubt, disclose, 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 get it in writing, and so forth. Number 5, the American with Disabilities Act. This is a tough one. There's the federal and then there's the state counterparts, some of which are more restrictive. Now, disabilities, obviously, we're not going to discriminate against someone who has an obvious disability. You know, we're nice people, we're not going to do it. Mental disabilities are included in that. So if someone says, you know, I've got a dog and I need that dog because I have PTSD, or, you know, it's my companion dog because I have mental problems, as silly as you may think that is, that's a legitimate disability. And you can't charge someone extra for the dog or an extra fee for the dog. Now, understand that the American with Disabilities Act, I'm not going to get into multi-unit and, you know, retail stores and things like that, because there are very specific regulations about access and elevators. Forgetting about that stuff. The American with Disabilities Act and the state counterparts require that you as a landlord make reasonable accommodations, reasonable ones. Is it reasonable for a tenant to say, well, you need to, you know, redo the whole house because my wheelchair doesn't fit through the doors and I need a ramp and all that, and it's going to cost tens of thousands of dollars in a single family home? No, that's an unreasonable accommodation. But if the tenant says, I want to install something temporary, you know, maybe made out of wood ramp, and, you know, make some small modifications that I could take out when I leave, you have to allow them to make that accommodation because that's reasonable, okay? So it all comes down to what is reasonable. Now, going back to American with Disabilities Act and mental things, what if someone, or physical, what if someone says, you know, I need to use medical marijuana, and it's too expensive for me to buy, so I need to grow it, which is legal in some states to grow in your house. Can you say, no, you can't grow it in my house because in order to grow, you're going to have to upgrade maybe the ventilation, maybe the electrical system, it's going to cause humidity, which could cause damage? I would argue in many cases that is probably an unreasonable request, and that you have a right to tell a tenant, no, you can't grow in my house, even though it's for medical use, okay? Now, there's very little law on this, so I'm not going to tell you to take my word for it. But that's what I would argue. I would argue that's an unreasonable accommodation, okay? Even if it's self-enclosed, you're going to need special electric, special ventilation, things like that. And if that's what's required, and it costs you as the landlord thousands of dollars to fix this, I would argue that's an unreasonable request, and you do not have to accommodate that. Okay? Number 6, security deposit issues. Now, often we take security deposits, and often we don't give them back, and legitimately because of unpaid rent, damages, and so forth. Now, every state has a law, a little different from state to state about the procedure and the number of days in the process, but let me just outline what the law requires. The law requires that within a certain number of days that you give back the security deposit, or detail in writing why you're withholding all or part of it. Detail it, not just summarize it, detail it, okay? And if you don't do that, and the tenant demands it back in writing, and usually it's, you know, certified mail, and a certain number of days you have to respond, and if you don't respond or give it back, even if you're right and you don't give it back, they could sue you for up to 3 times the amount, treble damages. Even if you're right, even if you were justified in holding it back, if you didn't detail why in time and within the procedures of the law, then you're going to have to give it back or face a fine, and then go sue them in small claims to get back the money you just gave back. So make sure you know what that is. Now, in most states, you can extend that period. Let's say it's 30 days. Your lease could say up to 60, but, you know, really you should be able to wrap that up within 30 days. What the damages are, detail why, lay it out, maybe give estimates or receipts of things you had to lay out of pocket, and that's the reason why you're withholding the security deposit. Okay? And the last thing is just kind of a potpourri of lease issues. And gee, we could spend a lot of time about lease issues, but let me go cover the highlights. Late payments, big thing. If you don't spell out that you're entitled to X dollars per day in addition to X dollars penalty, then you can't collect that. Now, state law may limit what you can collect as a penalty. Even if not, if it's unreasonable, a judge could say it's unreasonable. But, 5 or 10% of the payment, so if it's a $1,000 rent payment, $50 to $100 payment plus $10 per day, that's not unreasonable. Okay? $100 a day for $1,000 rent is unreasonable, so don't even try it. Okay? But make sure you spell out in your lease that any payments received are first applied to late payments, because if they get cute with you, you send them a notice saying you paid on the 10th, you owe me another $50, they ignore you, they send you another rent payment the next month without the late fee. If you don't say so in your lease, you can't just subtract the late fee out of that next payment. If your lease does say so, what you should do is say, let's say the rent is $1,000, late fee is $50, they ignore your notice, the next month they send you $1,000, you send a notice back saying we've taken that $1,000, applied the first $50 to the previous month's late fee, you only paid $9.50 for this month, you're $50 short. That's the way it should be done. Bounce checks, again, if your lease doesn't say so, you can't collect a fee for a bounce check, and nor could you demand that they make certified payments or certified payments from there on, or cash, unless your lease says so. Okay. Maintenance. There is an implied warranty of habitability that is required by law. Now, every state is a little different on what's included in that, but running water, electric, ventilation, free from leaks, free from the elements coming in. Even if it says in the lease the tenant is required to do that, you as the landlord have a duty, and you can't delegate that to the tenant in most states. Okay, so make sure you know what the warranty of habitability involves in your state. So, for example, air conditioning in Alaska might not be a habitability issue. Right? Heat certainly would be, but in Florida, air conditioning might be. So just be aware of what those things are. Look them up in your state statute. Go research it online and figure out what your requirements are as the landlord. Okay? The last thing is attorney's fees in the lease clause. Now, here's an interesting thing. Most leases will say if the landlord has to collect money from the tenant in court, the landlord's entitled to attorney's fees and collection. That's reasonable. But the reality is, especially low-end tenants, if you're going to evict them, you're going to get a money judgment for back rent plus attorney's fees, and you're never going to collect it. However, if you put in the lease that the landlord's entitled to attorney's fees when they win, in most states the law is reciprocal, meaning even if it doesn't say so, if the tenant wins, they get attorney's fees. And if they get some legal aid attorney or some cousin of theirs who's an attorney to represent them for free, and it's a $500 dispute, and they rack up $4,000 in legal fees and you lose, you end up with a $4,000 judgment against you as landlord. So what you might consider doing, particularly low-end tenants, and particularly if you don't think you're going to collect, and particularly if in your area there's a lot of free legal services attorneys, just take the clause out. Forget the winning party gets attorney's fees, because it's going to work against you anyway. Me, I've taken the clause out of my lease because it's worked against me more than it's worked for me. So consider that in your situation. Okay? This is just kind of scratching the surface. Do a little research. Buy some books on landlording and technique and laws in your state. Do some research. Be aware of the laws that apply to your business, and you will find that your risks of a landlord and your risk of getting bitten, not just by a dog, will go down substantially. This is Bill Bronchick. I hope you've enjoyed the 7 landlord liability issues.